What's up, everybody? This is an interesting one. We were asked about this by a few people. It is a transcript about 30 pages long. We're probably going to read about 20 pages of it. We're going to skip the pleasantries in the beginning and kind of dive right in to discuss what happened in Chambers when we discussed and kind of had an emergency press conference type of deal when Richard Allen's attorneys withdrew. We thought there were going to be some decisions made on some pleadings, potentially a Frank's motion hearing set. And instead, we get the breaking news that Richard Allen's attorneys have withdrawn. And the judge announced it. The attorneys didn't even do it in court. One of them didn't even file a written motion. It was very weird. It was very strange. We knew there was more to it. And to no surprise, there was a lot more to it, including a meeting that was had in Chambers. And to set the scene, as we're going to talk about this conversation that was had between the lawyers and the judge, it is not a secret conversation. It's not one that they think is going to be private. It is not something that anybody should be shocked if it ever does come to light. There's a court reporter there. They're on the record. All of it's being transcribed. And if something's being transcribed, it is possible then for it to come out and be read later in a transcript version. But that being said, it's not quite the same as something that happens in open court. The vibes feel a little bit different. Maybe there's not as strong of a filter. Maybe people say certain things that they wouldn't say in open court. So that just kind of helps us set the stage as to what the feel and the vibes are when you meet in Chambers before a hearing that you're prepared for, that you've had notice for, that you thought certain things were going to happen. They've exchanged telephone calls and emails prior to this, and then they get hit with this literal bombshell. So I'm going to read through it today. And we're going to, pause and discuss certain parts of it. I'll try to answer as many of your questions as I can as well. Hit that like button if you guys haven't already. And make sure you subscribe to the channel. We are like 5,500 subscribers away from 300,000 subscribers. What a Christmas gift that would be. So let's get into it here. This is an unusual one. I don't know how many times we're going to be reading transcripts together from things happening in Chambers. Usually the point of that is so that it's not for public consumption, but it always can be. And I mean, I always say, frankly, I know a lot of what I say now and do is recorded and blasted out there to the interwebs and will be seen and potentially listened to and watched forever. You should always speak as if other people are going to read or watch what you are saying. I think about that when I talk about these cases. I talk about these victims, I talk about these defendants, these lawyers, these judges, that they could actually watch this or see this one day. And it is incredibly insane to me that sometimes that actually happens. But I don't want to feel bad about what I'm saying. That's why I try not to name call and belittle people, not to be condescending. I will disagree. I'll try to do it as respectfully as I can, and I'll try to give the reasons why I disagree. But it's important to kind of go through life like that. You ever sent the wrong text message to the wrong person or copied someone on the email you were talking about or whatever? One or two of those, and it'll really shock your conscience and be like, I need to be more conscious about how I talk about people, about how I talk to people. And that's the way, frankly, you should just kind of live your life, not just with a filter so other people don't hear it, but maybe you shouldn't say certain things. Maybe we should try to be more positive and only say things that are going to be building up or need to be said, and not things that are just going to be tearing people down. Now, I will say some things are negative, and sometimes you got to talk negative about certain things when we have these criminal cases and people get convicted and they've done horrible things. You gotta speak truth still. But we're going to read here about this discussion and just keeping all that in mind. So Mr. Rosie, which is one of Richard Allen's attorneys, says, obviously, I'm happy to hear that the court's going to make some decisions on the pending pleadings today. I wanted to say something. So we hang out a lot on this channel together, and we share a lot of insights. And so actually I'll save it. There's a personal thing I want to talk about at the end. That's just kind of funny, that you guys remind me to. Hopefully I don't sign off too quick, but, sorry for that interruption. It just reminded me because I heard a squeak under the table. So the court, Mr. Rosie, I think is how you say it. I assume Andy feels the same way. That's Andy, one of Richard Allen's other attorneys. it's time to kind of get some closure, if you will, with regard to those items so that we can move forward. It's probably obvious that the tension from our side is coming, from the words disqualification. No lawyer wants to hear that. But we know that prior to this in chambers meeting, and we know what happens after, but in the time when this is happening, the word disqualification has already been thrown around, but not determined as far as they know, that were murmured in the phone conference that we had a couple weeks ago. So they had a phone conference a couple weeks ago. The words disqualification were murmured. So that is at least some time period that has passed. And I don't know if the judge said it. I don't know if the state attorney said it, but those words were said. And then now a couple weeks later, here we are in chambers. We're going to talk about that more, about how this discussion started weeks ago, not a day ago, not an hour ago. I'm assuming you understand how that kind of raises the intensity level of the circumstances. Yeah. And I guess if I have a concern today, it's that, we're going to go out on the kind of in the public, so to speak, in the courtroom, on the record, and have a discussion about an ongoing investigation. And that's what I kind of gathered from the email, I think you invited Nick to talk about that if he wanted to. She says, It's funny. I would love to hear the court reporter say, Judge, if you could say yes or no for the record, that would make it better, which is what judges do during trials. It's like they instruct the witnesses. You have to say yes or no because does not translate well, or nodding your head. Mr. Rosie, I'll get it eventually. And, it makes me a little uncomfortable because I don't know. First of all, there are no pleadings that are pending, whether there are motions to disqualify or contempt citations or whatever they might be. That really frame any of the issues. And I have no problem. I don't have any problem talking about this stuff privately on the record in an ex parte type of confidential hearing. I just think it's difficult to expect that there will be any kind of structure to the idea, hey there, there's an ongoing investigation and just tell us what's going on. And I don't know that it has any relevance to what we're really trying to accomplish today. So, just taking this part here, Mr. Rosie is saying, you've had weeks since we started talking about this. There are no pleadings pending or motions scheduled. What does that mean? You guys know what pleadings are, whether you know it or not. When somebody files a motion to dismiss, when somebody files, we need a Frank's motion, when they're filing these documents where stuff has to happen in court, those are pleadings for the most part. So he's saying if somebody wanted to file a motion to disqualify, they file that pleading. What that triggers then is our opportunity as the defense attorney, Mr. Rosie, to respond to what they put in there. We get to go research, see what the case law says. How many times have we in this chat together, and it's happened to me in my career a ton, where lawyers will file things, they will cite cases, they will cite statutes, and they are just wrong, either in their reading or application of the statutes or the case law. It happens, sometimes on purpose, sometimes not. So just because somebody files a motion, just because somebody says something, even in a legal document, even said by a lawyer on the record under oath, does not mean it's true, and also doesn't mean it's right or applicable to this situation. So that's why it's so important. And everything in the law, every rule we write it has to be done by this time. There has to be enough time to respond. We have to have enough time to do our research. And if we want to bring witnesses, we need to gather those witnesses. So we need notice and opportunity to respond. Netwoman, thank you for gifting 10 memberships. Make that 20 memberships. Thank you so much. So they didn't have that opportunity, even though they knew this was an issue for weeks, number one. Number two, he doesn't know how any of this is relevant to what's going on today. And I kind of agree with him. This disqualification stuff comes from leaks of the crime scene photos and other things, and breaches potentially in the confidentiality of these documents that the defense lawyers have. We'll talk more about that as the video goes on. But how's that relevant to whether or not Richard Allen needs to be moved from one facility to another? What does that have to do with the Frank's motion? Was things that were put in search warrants or probable cause affidavits not true, not the whole truth? intentionally misleading. What does this have to do with that? And I think that's a pretty good question. I also don't know why Nick, I'm reading again, would want to talk about an ongoing investigation in public, knowing that in itself, excuse me, sorry, could be a little damaging to their circumstances. And so we're lawyers. We're used to having issues framed. We're used to having an opportunity to prepare. And that's what I was saying. I may have gotten off track. In all the statutes, it says you have to file it by this date. And this person has 10 days to respond. And if you're going to do a reply brief, it has to be done within 5 days or 24 hours or whatever it is. There are rules and timelines because people ask a lot of questions on this. And I love answering questions. And I try to answer as many as I can, as best as I can. But so much of being a lawyer, people are like, lawyers think on their feet. That's right. Good lawyers have to be quick and thinking on their feet and adaptive and reactive. But another key to being a great lawyer is you get a question, you need to be good at researching and finding the answer and figuring out a way to make your argument. That takes time. You're not going to know everything. Not every lawyer knows every statute and number and case off the back of their, almost at the back of their head. I can't even say one-liners. I got to go look them up because that's what we do as lawyers. We go and we find the answer and we frame things and we respond and we argue back and forth. The law allows time for research and drafting thoughtful responses. I don't have anything to hide, and I know he doesn't have anything to hide. You've maybe gathered that we've cooperated. We ran into the state police posts, our respective posts, if you will. And I had somebody advise me of my rights, and I waived those, and I gave a formal statement, and he did the same. I'm not sure that we're going to benefit or that this will be productive to just open the floor to this. And that's my biggest concern today. So they're talking about, do they have any criminal liability or problems with the leaks and things that happen in this case? And he's basically saying like, yeah, we've had lawyers advise us, maybe don't say anything because maybe there could be some criminal implication. We've waived that. We've cooperated. We've got nothing to hide. The court says, Here's Andrew Baldwin, another one of Richard Allen's attorneys, Andy, who was referenced earlier. This is him. And it was actually his connection in his office where the leaked documents were taken from, not Rosie. So I'm more of a, like the due process side. I'm not really sure that will or what will happen, but I just don't know. I don't know what's going to happen. And I would like the opportunity to know what's going to happen and prepare for their claiming or whatever before it happens. And again, it's not unusual or unfair to ask for time to prepare, especially something as big as this, where you're going to be publicly shamed and booted off a case for something they're accusing you of doing that hasn't been proven. Tiana, these are his, not original lawyers, actually. I think this is a second set of lawyers maybe, but these are the lawyers prior to the ones that were appointed by this court. And the ones that offered to stay on pro bono that Richard Allen wants to be his attorneys, we're going to hear more about that later, that are no longer his attorneys because of basically this in-chambers meeting. And I don't feel like, I don't want to say ambushed, but you did. But it's hard to know for me what to do when I don't know what's happening. There's not a pleading we can respond to, things like that. So, you had indicated that, when Nick said, I don't know if he said the word disqualification, but the court said, oh, he did. Was it that word? Okay. I don't know if he just said it in a more generic way. The court said negative response. And your response was, I'm leaning in that direction or something to those lines. And the court said, Meanwhile, we're about to find out. The court has already made a decision. The court has already prepared a statement that they're about to read. And the defense lawyers are still trying to catch up and figure out what happened, which is not how it's supposed to go and not fair. Put aside whether you think Richard Allen did it or not. Put aside even what case this is. And just think about what's happening. The state seemingly is going to ask for the defense attorneys to be disqualified, but they didn't actually file the motion. They didn't actually put their evidence or whatever they're alleging in a motion that could be responded to and have an evidentiary hearing or some kind of hearing on to determine whether or not that's actually true or correct. The judge has listened to just what the state said, not even scrutinizing it and going through the even motions, if the judge has already made up her mind, of a response and a hearing and argument. And the judge has already made up her mind to believe that and make major decisions that affect Richard Allen based on these accusations. It's kind of wild. Mr. Baldwin, And so that's, a cause of concern. I mean, we're still wanting to try this case in January, and I'm willing to, we have made changes at my office that will prevent this from ever happening again, and we can take directives from the court. We can, we're locked down every single thing on Delphi. It's in a dedicated room. We put locks on our conference room or the war room where this guy went, my friend went in and did this without my knowledge, and no document, whether it's benign or something super, like a crime scene photo, is ever going to be left alone for a single day, solitary second ever again. So, I'm hoping that that can be something that the court, can say, all right, that's fine. And then let's get on with the trial, but I'll shut up now. So again, and what's really interesting to me is somebody going in and stealing this, taking a picture of it, doing it. Is it negligent? Yes. Is it horrible? Yes. Does it make him incompetent to defend Richard Allen? Maybe I'm naive in saying no. I don't really think that makes him incompetent. What's best for Richard Allen? I think going to trial in January with the theories that the defense has brought forward. And I think that that's being discounted as to like what's actually best for Richard Allen. These guys believe in this theory, in this angle, in his innocence, I think. And that's the kind of lawyers in a case like this that can be really beneficial and can literally move mountains. And so I'm afraid that's just being kicked to the curb because crime scene photos were, and I don't want to belittle it. It was huge. It was horrible, especially the backlash and what happened afterwards and somebody taking his own life. And I mean, it's horribly sad and it's horrible that it happened. It should never happen. And we should do everything we can to prevent it. But to think that there's not a document out in my office that, our receptionist couldn't take a picture of and sell, or, one of our paralegals or a friend that, comes for a meeting or to talk to me or, whatever, that as they're walking out can't go in and take a picture of. It is possible. Now, it's very unlikely because we don't usually let people around confidential documents. But if somebody wanted to come in and break all the rules and try to sneak around and get to a document, it's possible. We have a locked front door. We have a locked back door. We have a security system. We have cameras. We have multiple people throughout our office that would stop that. All of our employees sign confidentiality agreements. Certain doors stay closed that have all the documents. But is it possible that somebody would break all the rules and betray our trust and try to steal a picture? Now, if it was a case like this and it was super high profile, then probably you'd kick that up a notch and make sure that didn't happen. So was it negligent? Yes. Was it wrong for him to allow this? Yes, absolutely. But does it mean he's incompetent and just can't even go forward in representing Richard Allen because of this? And even worse than that, Mr. Rosie, whose office it wasn't even, and he didn't even have any control over that, should he be kicked off the case? And there's more to come in this that would even show that this damage was even less so caused by these attorneys. Netwoman's not going to stop. So turn on your membership gifting because she's going to invite you into the fold so you can hang out with us on the members only hangs, which I think we're going to do some fun ones over Thanksgiving and stuff. If anybody wants to join the membership crew, and hopefully Netwoman and all the OGs will be there as well. Oh, and it's Netwoman's birthday, I believe. Arlene said, "Happy birthday, Netwoman." Happy birthday to you. Happy birthday, dear Netwoman. Happy birthday to you. Maria, Peter, do you listen to Defense Diaries on here? I've never listened to it. I follow his Twitter. I think I was on like Long Crime or Court TV or something with him once. And I follow his Twitter, and he's a good Twitter follow, and he posts a lot of stuff. He's an experienced criminal defense lawyer, and I know he does post a lot of stuff like documents and stuff on this. So yeah, he is a good Twitter follow. I don't know him personally or anything. Okay. Anything, Nick, Mr. McClelland, Judge, and this is the state. I guess my plan today was to give the court a summary of the investigation. I've got witnesses here and exhibits to present that go towards the investigation. I'm more than happy to hand those over to the defense. I know it may harm the investigation, but I think it would be important that the court hear these things. I guess the heart of it, investigation, I think it's important. I think the importance of you hearing it is outweighed by that. And so I have those things. I'm concerned that the leak is not just a one-time leak. The evidence that we have shows it's an ongoing leak However, it's being done, and it's just what's next. I have an issue. What's next? I mean, I spent the past 17 days investigating this night and day when I should have been focusing on preparing for trial. When I say night and day, I mean phone calls at 2 a.m., 3:30 a.m., night and day. And so that's where I'm at, Judge. Again, I'm an officer of the court. I'm reporting to the court what I know, and that's kind of where I see my role. Judge says, okay. So again, this is not to say that the state has a lot of evidence that maybe the lawyers were even worse off than we thought. And they should be able to present that, put it in a motion, have the argument. And if the judge feels they've been disqualified, that's within the judge's discretion to make that call. But doing it this way is where I have a problem with it. If the judge makes it, I mean, you guys have heard me disagree with judges I really like and respect on this channel. Just because I disagree with the judge's decision is not the same feeling I have here about how all of this went down. And I don't know if I should say trying to block or prolong or not turn over this in-chambers discussion where things felt like they were happening behind closed doors and not out in front of the public. And the threat of doing something in public. I don't love that either. Netwoman's going to give 10 more memberships just for her birthday. Just for her birthday. The court says, okay. Mr. Rosie says, this is starting to scream due process to me. I haven't seen any of these exhibits, and I don't know really, frankly, I don't know anything about this. And I'm not distancing myself from Mr. Baldwin. I'm just saying I have no connection with any of these people, okay? Yeah, it's Baldwin's friend. It's Baldwin's office. It's Baldwin's security measures. So why is Rosie being kicked off? And the idea, that's my comment. You probably can't tell when I'm reading and when I'm not, but that's why it's on the screen, because you can see what their words are versus mine. And the idea that somehow the prosecutor is going to get to roll out a bunch of statements and exhibits and, testimony without us having any forewarning or any idea, any way of scrutinizing that seems a little outside the boundaries of due process to me. Yeah. And like everything lawyers do in every statute and rule for filing these types of things. Plus, again, I get back to what is the relevance to what is going on in this case. Why are we going to use an open courtroom to air out an ancillary matter? It's not really connected in any way at this point to the proceedings that are ongoing, whether it's the Franks issue or anything of that nature. And I will tell you this, and I am prepared to show the court this. I would rather do it in private. This problem has been a problem from the very beginning. Okay, so now he's going to say this also limits. Thank you, Aaron. John, I think I accidentally just unstarred a super chat. If you could go back and grab it, scroll back up and see if you can grab it. Wiley, thanks for gifting 5 memberships. That's awesome. Wiley Coyote. So this is what I was talking about before, how he's going to give context to how damning or damaging really was releasing some of these photos. As horrible as it was, and we never should want it, but it's not like this is the first time anything's ever been leaked in this case. He says, I have 10 pages of a deposition transcript in this file from my deposition, our deposition that I took of Trooper Holman in this case. And in that deposition, he talks openly about how there were crime scene links from the very beginning, unequivocal crime scene links, and that as soon as this crime occurred, they were investigating information that had been released because there were lay people that were part of the search party. And the implication is, I've got the transcript, is that those people that found those girls started to essentially disseminate or distribute information, and law enforcement essentially tried to catch up with them, but it was really too late, as you might expect. Once it gets into the hands of the public, it's too late. So he told us that, almost volunteered that information to me in the deposition. The second concern I have is that I think I shared with the court just an example a week or two ago. Somebody sends me a court TV, bit. And I can assure you, I've never watched one of those bits on this case. I don't even know if I've ever really watched court TV. Maybe back when Simpson was ongoing. I don't know. And in that bit, Barbara McDonald is talking. 2 different occasions, she mentioned how she's getting information from investigators on the ground that were at the crime scene. Now, we can all draw implications about that. But most importantly, it was corroborated by the fact that she was holding in her hand documents that I know to be directly related to the Purdue report. I mean, I saw the pictures. I know where those came from. And if the point here is I'm going to say this maybe a little loosely, but forgive me. I don't care. I don't care that all that stuff is out there because it's been out there for 5 or 6 years. I don't have time. He doesn't have time. He doesn't have time to sit and try to marshal all of this stuff while this case is ongoing because there's no end to it. But the point is the court needs to have some context that is nothing new. I lost sleep over the fact that there's a man who's dead that I don't even know. And frankly, Andy doesn't know. And it's tragic. I don't know what life circumstances he had or what surrounded this. None of that information has been shared with us. But at the end of the day, what's going on out in the cyber world and in the public, as you might expect in the case of this magnitude that's been publicized for 6 years, was beyond our control before we ever got involved. I think that's kind of a good point. I think that's kind of a good point. Okay. Mr. Baldwin chimes in and said, there's even a guy in Florida who says that the guy in Texas who leaked all this stuff has received from a disgruntled Carroll County employee a whole file filled with stuff and photos included. And I haven't seen the photos that were leaked. I don't know what they are. I mean, if this could be set for a formal hearing in the future where we have a chance to do it right away, then that's one thing. But, to go in there and we don't have any counter way to counteract anything. If I know what it is, I can, okay, I know what that is, or I don't know what that is. And it's, and in the meantime, we can, I don't know. This is the lowest point of my career right now because somebody did what they did to me. And that has nothing to do with Richard Allen. And the court said it certainly does not. So the court's acting like because of this, they're killing Richard Allen's case. And I don't think that that's the case. I think it's horrible what happened. I think it never should happen. But I kind of agree with Mr. Rosie's position where it's like, Judge, this stuff has been out there. And I'll just tell you, me personally, Peter Trago speaking, multiple people have reached out to me in this case and have said, I have this, I have that, I have information. And I'm very cautious and careful to talk to any of them. I told every single one of them, don't send me anything. I don't want anything that could be privileged and you might not know what's privileged or confidential. So don't send me anything. I've tried to be nice to everybody, but there is stuff out there. I will just say there is stuff out there on this case. And some people will try to get it. John O'Rourke, do you think this makes a judge more human-like instead of a robotic? Interesting transcript mentioning law and crime is wild. I think judges are human. I don't think they're very robotic. And I think sometimes it comes out. The problem here is we have a process of doing this. I don't know if any of you guys have been in HOA or we do it on our committee meetings, like for the Florida Bar when we're writing rules, right? It's like, so we talk about stuff. We're like, yeah, we all want to do it. It's like, no. Somebody's got to make the motion. Somebody's got to second it. We've got to take a vote. We've got to write down the votes, the yays, the nays, who abstains. Do we have a quorum or enough people here to vote? There has to be a process. And while sometimes you might not understand the process or know why the process is there, we've got to stick to the process. And I think this judge just did not stick to the process. That's the major issue. If she wants to make a decision, she has the right to make a decision. She's a judge. But we need due process. Richard Allen needs to have counsel there. So I just don't want to go in there and not be able to fight back with the evidence that or witnesses that we have to counteract whatever they claim that they have. So here's what the court says. So now the court starts. Okay, here are my thoughts in no particular order. I don't know how many folks are out there, and I certainly don't wish to air publicly to the world the concerns that I have about this matter. My intent in having this hearing was to go through some of the pleadings that we have not yet decided. So I was going to start with reminding everybody about the decorum in the courtroom, everybody here, shut up, etc. There have been reports to my sheriff about disruptive people. I'll remind them if they're disruptive, they'll be removed. My sheriff's fully prepared to execute arrests if necessary. Sheesh. Because I know we've seen in our other hearings, people have been disruptive and hateful. So under the rules, under the canons of judicial conduct, I'm required to advise people within the room that the media is here and they're filming. They're doing pool coverage. So there's only 2 cameras in the courtroom and everybody's going to get coverage from that. And then I want to talk about the pleadings. Here we go. Defendant filed a verified motion for immediate transfer of custody. The state filed its response. The motion, again, has a lot of inaccuracies and some speculation, and it has been refuted ably, I think, by the affidavits that have been submitted by the state. and I'm going to deny the motion. So this is interesting. This is the motion that, Richard Allen says he's being abused. The lawyers, have things in there about the cult, the Odinism stuff. And even another inmate said he saw Richard Allen being abused. Obviously, people from the jail have said he hasn't been abused. And it's been refuted by affidavits and statements made by, people in and around the jail. Duh, that's what they're going to say. They're not going to admit committing crimes, I wouldn't think. And again, the judge can look at both sides and say, I believe one side and not the other. And that is, yes, that was it, John. Okay. He got creeds. This is the one that I missed. Judge Gull, with all due respect and all due process, which is not go away by. Also, the prep statement finding was made from ex parte facts. Creed, they're like unsubstantiated facts, unscrutinized facts, no opportunity for cross-examination or arguments to be made by the lawyers on the other side, or lawyers to be able to call rebuttal witnesses to respond to what was being said. This is spot on. Spot on. What I was saying there is the judge just basically says what you put in there was false and speculation. It's like it was sworn testimony under oath. So, I mean, you can call it false. You cannot believe it, but like we're not lying, but that's what it feels like. And so she denies Richard Allen's motion to move facilities, which I think is really weird. Like if I was a judge and I had even an inkling of abuse or really thought, wow, maybe there's something there. And if there is something there, the damage that would cause, let's move him if we can. Now, it's easier said than done, but still, I mean, it's just wild. It's like, nope. Demonstrably false because people that, work or are connected to the prison say that's not happening. I'm going to deny that motion. The defendant then filed a motion for a broadcasting order. The state filed its response. Your motion's overbroad. It's got a lot of irrelevant verbiage in it, and I'm required to consider individual requests for hearings, so I will. If the media wishes to have an individual request submitted, they know fully well how to do that, and I've provided to counsel all of those requests that I've gotten so far for this hearing. So again, she takes some shots at their motion being overbroad and using irrelevant verbiage. So if you want to file them for particular hearings, you're certainly welcome to do that, but the media is all over this, and they're not. They know how to do this. Mr. Rosie said, yeah, I was just trying to understand. Are you suggesting you're going to determine on a case-by-case or hearing-by-hearing basis? She says hearing. Okay, yeah. Mr. Rosie, all right. Okay, I just want to make sure. The court. The state filed its motion for leave of court to subpoena third-party records. I think that was directed again to DOC. I clearly can't grant that. I'm going to grant the defendant's motion to quash. But if you continue to raise his medical and mental health in pleadings, that's fair game then for that to be provided to the state. It's weird that she would say this knowing she's going to boot him off the case. You've also filed, Mr. McClelland, a motion for future pleadings and filings to be sealed prior to being released to the public. I've gotten a response from the defense. Mr. Rosie said, can I speak? The court says, sure. I think it's important to note that, we had this discussion come up before. Basically, we decided we're done sealing stuff. We're going to make it public. Before we filed the Frank's brief, I had a long conversation with the court reporter, Karen Allen, over in Delphi because I wasn't sure about, is it Allen or Roller? I always want to call her Karen Allen, Karen Allen, okay? Because I wasn't sure about the mechanics of how all this stuff was getting moved from Delphi to your office. And I know that you had set up some kind of website. This is basically them just saying, how are we going to keep stuff confidential? I'm going to skip ahead a little bit. No, and that's why I was talking to her, that way I understand the mechanics. I was part of one of those conversations. That's what she said. So do we need anything for the hearing? Happy to have a hearing. The court said, no, I'm just telling you for context. Could there be a happy medium if we file it confidentially? So the judge then just gets a chance to review it first because I thought that was going on anyway. But if it's not, it's going on. Court said, no, it's being filed confidentially. If you mark it as such, they say, yeah. The court said, I had my staff mark the memorandum confidential after it had been filed and disseminated to the public because the actual warrant was in there and that's covered under a miscellaneous cause number. I'm happy to have a hearing. Well, what is your ruling? I guess to make sure I understand. I don't want to fight about something we don't need to argue about. Court says, I haven't ruled on that. Says, okay, you haven't filed a response. and that? And he says, yeah. All right. Then the court says, my question is, do we need a hearing on that, or do you wish to file a response? The Franks motion clearly needs a ruling, and I'm working on that. The motion and exhibits are about 1,500 pages, and there are hours and hours and hours of interviews that have been made available that my IT staff has now cleaned to make sure they're okay. Cleaned? We already talked about that. And then, that brings us to my concerns that I raised with all of you on our phone call. And I write everything out. And this is what I intend to say in open court. So this is a prepared statement prior to this hearing in chambers that she already planned to read out. Okay, here it is. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation. So again, this isn't just one leak. This isn't just because something got out there. This is that she thinks she is not comfortable allowing them to continue to represent Richard Allen because of the totality of the circumstances. And candidly, my concerns began at our hearing on November 22nd of last year, way before any of this stuff happened. Mr. McClelland filed a motion for a gag order, and we were in chambers, and you assured me, gentlemen, we don't want the media in our lives. We will not try this case in the media. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew or should have known those were potentially violative of Rule 3.6 of the Rules of Professional Responsibility. You knew or should have known, okay, I'm just going to read that again. She says you knew or should have known that those were potentially violative. Not that they did violate, but that they potentially could. And it also seems like she wants them to not have anything aired out publicly. And she finds that having things aired out publicly with press releases and no gag orders and cameras in the courtroom definitely feels like she thinks that's a negative. Lawyers have been doing this since the beginning of the media. We did a whole podcast on how important the media is to this process, how they can be bad, but they can also be very, very good and important. It seems like she's already made a decision that she only wants lawyers that will agree with not doing it that way. It's one thing to try this case in the media. It's another thing to have public proceedings that the people can see and the public can see. But it is that press release that prompted me to issue the order on December 2nd, granting the gag order until further hearing. April 18th of this year, you filed a notice of tort claim against the Department of Corrections. Okay, first off, before we get there, so they say those things and then she grants a gag order. That's the appropriate process. If there was no gag order in place, what did they really violate? Did they violate the rules of professional responsibility or did they not? So then they file a notice of tort claim against the Department of Corrections. And this is very interesting. You stated in that notice that it was your intent to pursue our client's claims against you. The full amount of damages sought on behalf of my client is unknown. That is a very generic and normal statement you would see in a tort claim like this where somebody is being abused in prison. It happens. There are laws in place for it. There are damages that they have to pay. And while it's difficult, obviously, it's not a very likable client in a PI case when they're in prison on murder charges, but it does happen because they can get abused and they shouldn't be abused, especially, anybody in prison should not be abused by prison guard or other prisoners, regardless of what they've done. That's not part of the punishment, but especially people that are innocent until proven guilty. And she takes issue with the fact that they said this. She takes issue with the fact that a lawyer says their client has claims against the DOC and they don't know the full extent of the damages yet because he is still being abused. And it could affect him going into the future. And she says, I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. I think that's inappropriate. Based on what is what I would say. Based on what? Why is this inappropriate? And I tell you what's not inappropriate is Netwoman just continuing to give memberships. So she thinks that a lawyer cannot represent a client criminally and civilly? Unless there's a rule I'm not aware of in Indiana, that's absolutely appropriate. And many times it happens. A lot of times somebody gets arrested for battery when they're actually the victim and they sue the civil defendant who is the criminal victim because sometimes we get facts wrong. So I don't understand how this is inappropriate at all. I mean, it's directly related. Now, what's different is if they're court appointed counsel and not his chosen paid counsel out of his pocket, that could create some issues, right? They can't bill the taxpayers for representing him on the civil case. They can take it contingency, they can take it pro bono, but they can represent him. I don't see why they could not. So I don't know why she says that's inappropriate. Wiley said, less transparency, not good. Never good. Never good. Nirvana, move him to where another prison facility. It's not like they're going to like move him to a hotel, just another prison facility. Maybe that doesn't have what they're saying, the odinist, guards that are abusing him, if that's even true, which, we don't necessarily know. Alice said, thank you. And please keep covering. Sunlight is the best disinfectant. I believe something bad is going on in Indiana. Everyone look up the Flora Fire girls. Lisa S. Every leak example and court TV they cite here was pre-gag order. Also, if he was so ambushed, why did he hire his own defense attorney and file a memo? I think what he's saying he's ambushed by, Lisa, is that he's ambushed that she's going to try to remove him from the case without a motion and a hearing. Because that's just normal. And lawyers, that's what the rules say. And lawyers are very rule-oriented. So to not see a motion, they're thinking they're coming into a hearing to talk about one thing. Judges almost never hold hearings on things if you don't file a motion and the other side has had time to respond, even if it's obvious and simple. So I think that's what they meant by ambush. Not to know that there weren't issues. They absolutely knew there were issues, and the judge in her discretion could make this call. But the way it's being done, that's the problem. And that's the context that, we're trying to determine here throughout. Wiley said, easier said than done. Yes, but if Goal said it, it would have been done. And I think you're talking about moving from one facility to the next. Netwoman, 10 more. 10 more. Okay, that's inappropriate, I think she said. May of this year, we were notified by the state of Brandon Woodhouse's arrest and the subsequent discovery of your work product. And I think it was an outline that you created for yourselves with the discovery. It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year, and that was not revealed to anybody, not shared with the court, wasn't shared with you, although apparently you guys knew about what was going on. And Baldwin said he didn't know. I think he's pointing to Rosie, and the court said you knew, and Baldwin said I did know. So again, I am not saying they didn't do anything wrong. I am not saying that this is okay. I'm not saying it's impossible for a judge to come to this conclusion, right? If we have a hearing, we hear the state's evidence, it seems really bad, they seem totally incompetent, at least Baldwin potentially, and she removed him, then so be it. That happens sometimes in cases. But the way that this is happening here is what I really have a problem with. And again, we are not talking guilt or innocence of Richard Allen. Glenn F. says, it seems that the defense team has been accurate so far in their description of the closed door convo. It makes me wonder what else has been happening. I hope the judge is removed and the lawyers put back on the case. Yeah, they did describe kind of how this went. And so far it does kind of seem like it's going how they said it went. So then Mr. Woodhouse gets arrested and here we are. Grossly negligent to email that to the wrong Brad. Your pleadings on the safekeeping order contain inaccuracies and falsehoods. Interesting. That was proven in the hearing we conducted in June. The evidence presented by the state clearly demonstrated the falsity of your claims, and that was very troubling to me. And then, so to me, we're starting to wade into the water now of if you think this lawyer is lying and presenting falsities and misleading the court, then they should be sanctioned and reprimanded and potentially reported to the bar. We can't do that as lawyers. A private reprimanding and letting him walk away to continue to represent other clients is troubling to me as a lawyer. I'm not trying to get anybody in trouble or say we need to take this guy's livelihood or anything like that. That's not what I mean. I'm saying if what she's saying is true, this is a much bigger problem than just this case. And we need to handle it that way. But if we're just trying to stack up reasons why to get him off this case, it's concerning to me how this is the way that this is happening. The state provided you discovery that has been severely compromised. We now have an ongoing investigation. I'm not going to call it a criminal investigation, but you said it. I don't know what it is, but it's clearly being investigated by the state of Indiana. Everyone involved has sought counsel, including you, Mr. Baldwin. You've had an attorney enter a written appearance this morning. Do you think that, hiring counsel, think the judge has a negative connotation on that? Or maybe like Lisa said, maybe she's just saying you did have notice of this. You even hired a lawyer. I don't want to get into that investigation candidly. You are the constitutional authority for the state of Indiana. If you choose to pursue it, that is up to you. If you choose to abandon it, that is clearly up to you. I'm glad to hear that you have cooperated, but Mr. Baldwin's attorney has clearly shared. I don't know if you've seen his pleading. I saw it, Judge, Mr. McLennan said. I got it kind of late. He emailed it to us and then, okay, I saw that it was filed on the way here. The court. Well, yeah. So he's clearly shared it in his pleading down to the fact that an individual has committed S. He included the fact that you left materials all over your conference room table, accessible to anyone, and this is a friend of yours who apparently you have consulted with on this case. So I don't know all of the details about everything going on in the background, okay? I don't know who this friend is, the lawyer, judge, investigator, whatever, but if you have somebody that's an expert that you also call a friend that you're consulting on the case, you can have them sign a confidentiality agreement. You can do everything you can, but if they're consulting on the case, which you're allowed to do, and if you think that's the best defense, you should do that to help your client. If they're going to breach your trust and confidentiality and do this, there's only so much you can do to block that and to vet people's character and trustworthiness. And you never know when potentially greed or looking for fame is going to overcome somebody's character. And I don't want to belittle this because this is horrible. This has never happened to us in a case. I hope it never does happen to us. And we take a million precautions. But I'm not above it and going to say, there's no way this could ever happen in a law office. We are so virtual now, thank God. But I mean, these guys, and like my dad is very paper intensive. So there are papers that if somebody wanted to, sneak in here, or a friend of ours working on a case or whatever, our, process server that's serving a bunch of complaints, if he wants to pop in here and say, hey, I wanted to look at that file for the complaint that I'm going to serve, and he takes pictures and steals stuff and sells it, it's like, how much control do you really have for people working on the case? Here's a good question. Lone Pony, just curious, would you have withdrawn? I haven't thought about this until right now when you asked me. I would say if I was Baldwin, I would probably withdraw. If I was Rosie, no way would I have withdrawn. No way. And I get what he's trying to do in protecting his reputation, but sometimes, and I think he's figuring it out now, he's like, you know what? Bump that. Let's go. I want everybody to hear how you pushed us and threatened us and what we actually did. And I'm going to stand up for my character because it's not true and it's not appropriate. And so far, a lot of her hammering has been on Baldwin, not a lot on Rosie. So again, it's up to you if you wish to pursue that. I'm looking at the totality of the circumstances. When I look at a suppression, the case law requires me to look at the totality of the circumstances, and that's what I'm doing. And it pains me to say this, but the totality of these circumstances demonstrate gross negligence and incompetence on the part of the defense team. So it's not just allowing a leak. It's you are incompetent to handle this defense. I am unsatisfied with your representation of Mr. Allen because of what they're doing for him, because of what they're filing, or because of their, maybe she thinks because they went to the media, because they did a press conference, because they didn't want a gag order, because they do want cameras in the courtroom. Maybe, in her heart of hearts, she believes they wanted this stuff to get leaked and they want this stuff to be tried in the court, in the media. Maybe. I don't know. I am gravely concerned about his rights to have competent, non-negligent representation. So you tell me, do you think negligently allowing somebody to leak a photo like this means that they are not competent to represent Richard Allen? It's just an interesting question. He currently doesn't have that right now because what you have demonstrated is negligence and incompetence. Now, I am sharing my thoughts with you privately. Here's the threat. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. I don't want this coming out. It is not where we need to be with this case, but I will. That's a clear threat. But you don't know that. You have just now been made aware of my concerns and where I'm landing. So anybody that thinks they had notice, the judge admits right here, they had no notice of the judge's statement, even though it was written prior to this, and even though conversations have been happening for weeks. You don't know that. You've been just made aware of my concerns and where I'm landing. So if you wish to have a private conversation, I would encourage you to do that. I don't believe your client is here yet. No, he's not. Clearly, you'll need to speak with him as well. Baldwin says, I'm not good at reading between the lines. The court says, you're a lawyer. That's what you do for a living. I don't know that I agree with that, but you should be able to read between the lines. Mr. Baldwin said, when you say have a private conversation, do you mean the four of us? Or it's like, oof, you really don't know how to read between the lines. I'm talking to you. I'm not accusing the state of gross incompetence and negligence. I'm finding, so she says, I'm not accusing the state. I'm finding gross incompetence and negligence with you. So I'm not even accusing you of it. Signed, sealed, delivered. I've made my decision. I'm finding incompetence and negligence with you based off of things the state said and things I'm looking at in the record, not based on a motion filed by the state, a response filed by you, and a hearing had with arguments and potentially testimony and evidence. Not that way, not the right way. And that's where the beef comes in. So, okay, forgive me. No. Mr. Rosie says, I mean, obviously, reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will, if that's the right term. Is there a scenario where the court would accept if I stayed on the case? I mean, I'm a team player, and I'm not the kind of guy just to bail out on someone just for the sake of doing it. But I think it's obvious that, he can speak differently, but I'm not as connected to some of, this most recent circumstances as he is. Mr. Allen is in a situation where he's going to have counsel. That's if he has new counsel, it's going to take him a year to get up to speed with the depth of information that continues to come in. And so I think that his Sixth Amendment rights matter. And I'm probably the one that can at least move this thing forward with some kind of judicial economy. I don't like it. That's not what I intended to do when I came in here today. But that would kind of be worst case scenario on our side, I guess. And so is that an option that the court would entertain? No. Which answers our question. Is it just about the leak? Is it just about what happened with Baldwin's friend with the papers on the conference room? That's really the only factual scenario the judge mentioned besides a press conference. That's what she mentioned. So that's the only thing she put on record here in this in-chambers meeting as to the reason for gross negligence and incompetence to the level that she does not feel comfortable with them representing Richard Allen. So what part of that connects Rosie? And is that enough on its own? And if there's a slew of other problems, which there very well may be, why isn't it on the record? Why isn't she taking that into account in making her decision? So basically what you're saying is you guys either quit on your own accord or you make me fire you. No, the court says, I'm saying to you that this is what I plan to say in court on the record. All the cameras are there when we convene at 2:00. Well, so is the culmination of that you're removing us from the case? The court says, I will, based on what I've just shared with you. So there's no doubt she will remove them if they don't leave. Okay, well, I just want to make sure and I'm just giving you the opportunity to have a conversation. How do you want that to go? I don't want to do this. But I will if I have to. I will publicly shame you and remove you from this case if I have to, basically is what she's saying. Baldwin says, should we bow out gracefully, as Brad says? How would we even have a hearing? How would that go? Because if we're out of the case, then Rosie said, then you're going to go ahead and rule on a bunch of stuff without lawyers in the courtroom. No, I wouldn't do that. If you decide that your best course of action is to file a motion to withdraw, it's interesting how matter-of-factly she's being about it. You can do that today, and I'll send Mr. Allen back to the DOC after you've had a chance to speak with him. Yeah, who cares about that? We don't need to decide that stuff today. We'll just delay it a little bit more. We'll decide this stuff later. We'll kick his trial out, 10 months, which they ended up doing. Would that happen before the hearing or after the hearing? The court said, your motion to withdraw would happen before the hearing. Baldwin said, okay, that's what I wanted. Yeah. The court says, yeah, because he has rights, and I don't want those rights compromised by having a hearing with him not having counsel. Yeah, that would be really bad. I assume if you choose to withdraw that his financial situation hasn't changed and he would still be entitled to court-appointed counsel. I can't imagine that he has the ability at this point to hire counsel. I don't know that. Baldwin said, Brad and I need to go talk. Court said, yes. Thank you, Judge. They go off the record. You're welcome. Yes. All right, let me answer a few questions here. Max Sauce. Peter, what are your thoughts of him being in prison awaiting trial versus county jail? Seems like another odd detail violation of his rights. So every jurisdiction has different rules. Andrea Burkhart, I don't know if you guys follow her on Twitter. Somebody asked her about why he shows up in shackles and Koberger shows up in a suit and tie. And she explains the differences in different jurisdictions, decisions that they make, how facilities are handled and pretrial detention is handled. And it was a really good post. So I encourage you to go check that out. Nirvana said not in Indiana. Are you saying that's the only place they'd find somebody that wouldn't abuse him? Netwoman, is everybody subscribed to the channel? That's a great question. You guys answer that. Hit subscribe so that we can get Peter to 300,000 subscribers. That would be awesome if you guys would do that. Cat Yarb said, why is he in prison, not jail? 1 year membership anniversary yesterday. Crazy how fast a year flies. Cat Yarb, thank you so much. So I don't know the answer to this. There may be an easy answer, but sometimes we've had federal prisons and state jail and vice versa. And it depends on what each facility can handle. Sometimes the dangerousness or the extra security that's needed for certain defendants. Sometimes it's just rules. Sometimes it's placement. Sometimes different jurisdictions, that's just how it works. So I don't know the answer specifically in Indiana. Nirvana, this case is so stressful. He would be in more danger in the jail. Everyone doing real time is held in Westville. It's hard to find pity for him. He is part of this pedo ring. Are you talking about Richard Allen? I am not casting judgment or making decisions on any of that stuff. Honestly, he could be the killer. He could be in this ring. I don't know. He could be horrible. A lot of horrible people could be in here. I am just looking on how this process worked, how I think due process was not carried out here, how this was not done per the rules appropriately and kind of done back in secret and now coming to light. So I don't love a lot of those aspects. Xena, how likely is it that Judge Gull will be held accountable? So I'm not saying she should be like fired or sanctioned or thrown in jail based off this. What I think needs to happen is it needs to be kicked back. We need to do it the right way. See if they're thrown off. See if Richard Allen should be allowed to hire them on his own pro bono if they're willing to do that. That's really the reprimand and the remedy we need for this, I think. Now, if she's been doing this in every case and there's some long-standing problem with her doing things like this, then sure, maybe a reprimand is warranted. But I'm not just going to say that based off of one in Chambers transcript. Wiley, this is where things get really ugly. It's already been beyond tough for the victims, but the system adding to the pain is just so hard for everyone. And then Wiley said system/process. Yeah, all these delays, while bad for Richard Allen, are also horrible on the victims and their families. To not have answers, to have lawyers shuffled in and out, to have these questions brought up and then maybe never get answered. Like Richard Allen's prior lawyers, maybe they think it's all BS, but what if they're like, holy crap, what is the truth here? Are we ever going to hear this all presented to a jury and get some finality to this? Really problematic. Netwoman, 10 memberships. Then another 20 memberships. Somebody made a post earlier that they think she's like, leaning on her membership clicking button and just keeps accidentally clicking it. Thank you so much, Netwoman. All right, let's keep reading. Mr. Rosie said, all right, so obviously we're kind of trying to figure out how to address this issue on very, very short notice, very little notice. The first thing we did is really talk to the client. The judge says. Our client is a big part of it, the biggest part of this. And he has communicated to us that he does not want us to withdraw from this case. He wants us to continue with his representation. He understands, I think, that he's not the gatekeeper or he doesn't have authority to really force the court to do that. He would like to say that on the record. We asked him if that's what he wanted to do. We suggested maybe he would do it in chambers. It seems a little bit of a difficult position to put a man who's accused but not been found guilty, to put him in the courtroom and have him speak this circumstances with 15 minutes notice. Yeah, you don't want him to waive his rights and accidentally say something that he shouldn't. if he gets nervous or whatever, or that can be held or used against him in the future. Andy and I'm going to speak for myself. I'll let him speak for himself. I'm going to file a motion to withdraw. I don't want to do it, but I think that I don't think that I have a choice at this point. And I think he's right about that. The options I've been given without any notice, again, he's a lawyer, he's smart, and he's putting context on all this without any notice. He is speaking like this is going to get transcribed. He is speaking like he knows this is going to come out later. I'm not so sure everybody else is. The options I've been given without any notice by the court really are either I withdraw or I'm going to be publicly shamed. And that's the way I see this. And I think that public shaming is there's not only a professional element to that. I think there's a personal aspect to that too. Interesting. But because that is true, like she could make those findings, but she could also just not say it all on the record and still say totality of circumstances, she's removing them or disqualifying them. Interesting. But when the media is teed up like this, and, we show up here today with the court having told us that we were going to conduct some business, and that somehow bleeds over into a forced resignation or however you want to characterize this, that, I don't feel like I have any other choice professionally. I have a life beyond this courtroom and beyond this case, and I have a family too, and I have a law practice. But I think we had been given some notice of what we were actually, if this would have been framed in a pleading format or some formal disciplinary claim, which there's a process for that in our business, when we could have come in here today with an opportunity to refute some of those things that you clearly had, thought through and prepared before we got here, and we didn't have that opportunity. And it's the idea that I'm going to have to go in here and open courtroom and essentially defend myself against claims that I don't agree with without any notice and without any opportunity. I think it's unfair. But I also have common sense. And, me going in there and standing my ground because my client wants me to is just going to make things worse for him. So I'm going to withdraw my appearance. I'm going to walk out of here. I'm going to go down to my car. I'm going to call my staff and I'm going to have them prepare a motion and I'm going to withdraw my appearance. But I'm doing it, to be clear, because I don't think I have any other choice professionally, not because I want to and not because my client wants me to. And I respect the court as an opinion, but we're professionals and we can disagree. I agree with that. Welcome, Donchi, Sardanisms, and all the new members, all of Netwoman's new members as well. Thank you, Netwoman. The judge says, of course. And Mr. Rosie says, and I'm extremely, I'd say frustrated probably is a soft word with the idea that we showed up today without any real opportunity to prepare for any of this. And I just think it's improper. And that's where I am. And that's my position. The court said, well, I think we talked about it when you asked for a disqualification. And I indicated on our phone conversation, I'm inclined to do that. Mr. Rosie said it was a phone conversation that was not on the record. And then some follow-up emails. Court said, true. There's an informality to that. Court says, true. So Rosie says, and you also said that you hadn't even done any research and you hadn't, had time to talk to your senior judge and all these things. And he hasn't filed a pleading with the court either. The court says, no, I'm doing this on my motion. Well, where's that? Can we see that? Rosie says, and I'm a lawyer who practices in lots of courtrooms, and I've been through some disqualification actions. In 20 years, I've never had a disciplinary complaint that in my life that's been confirmed, if you will. So especially criminal defense attorneys, a lot of people complain, as you can imagine. They're mad when they go to jail. But just because somebody complains doesn't mean it's confirmed. It doesn't mean it's legitimate. And that's what he means. Not to say that nobody's ever complained about him. I'm sure if you're a criminal defense lawyer and you're doing a lot of these types of cases, you're going to get complaints. But I've seen lawyers disqualified, and there is a process for that. And it's not this. With all due respect, where you walk into somebody's office, a judge's office, and they read a prepared statement to you. And essentially that statement is an indictment on my profession, activities. And then you're handed essentially a sheet of paper with two options. And one of them is, I'm going to go out here and shame you, or you can quit. You can understand how upset that would make any lawyer. And I just think I don't think it's the right way to handle this from due process standpoint. So I have no choice but to, withdraw my appearance because I'm going to go in there and take a public shaming without having any notice. I just, that's where I am with it. Baldwin says, I'm the same, withdrawing. I mirror what he said. I mean, I do appreciate giving us this advance notice. He's like, I appreciate you not going in there and publicly shaming us. If there is some appreciation for that, I do appreciate that. But beyond that, I wanted to take this, finish it out. I'm stunned. I don't know what to say. So I'll just say I'm moving to withdraw orally. Okay. Mr. Rosie said, is the court going to generate some further instructions on what to do with the discovery? Like, what are we supposed to do with all of this? I'm asking about the possession of all the information. Do I take it to the trash can? The judge is like, I already have an order on that. When I granted the state's protective order, the last paragraph says, you're going to return it all to the state of Indiana. He goes, yeah, the conclusion of the case. She says, no, or your representation, which is concluding now. And he said he read your order. So we're just supposed to take everything back and give it to the state and just retain our work product until somebody comes for it. She says your work product is your work product. I mean, I would hope that you would share that with your successor counsel. I would hope that you would help successor counsel just with the transfer of all of the information, because that's in your client's best interest to do that. But that's entirely up to you. Yeah, she probably doesn't want them actually helping successor counsel or telling them, do this or do that. That's your work product that you have developed. I mean, clearly the discovery is required to go back to the state. Rosie said, okay, thank you. What do you want us to do with Mr. Allen? Court said, I can transport him back to the DOC. Mr. Rosie said, do you want to make a record with this? I mean, I think it's appropriate that the court let him speak into the record, his thoughts, unless the court just accepts that as notice that those are his opinions. Court says, well, you wouldn't lie to me about that. Rosie says, I wouldn't lie to you about anything. Court says, so of course, although she just said they presented things that were objectively false and refuted by the state's evidence, but the court said, that's your representation. That's what he would say if he was brought in here. I can't imagine the DOC being comfortable bringing him into my office, and I would not be comfortable having him in my office. Would the court also be inclined to mark and exhibit the prepared statement? And she says, I have the record rolling. Rosie says, okay. And the court says, yes. So I think the answer is yes, that she did attach her statement, but I don't know. We also heard her read it. Baldwin. So we're going to leave, I guess. And how is this? You're just going to get up on the bench and say, the court said, I will just indicate Mr. McClelland's going to be in there with Mr. Luttrell, and I'll just say we've had a turn of events and defense counsel's withdrawing, and that's all I'm going to say. Baldwin said, can you wait for us to get out of here? I thought that was interesting. Like, they want to run out the back door. I mean, I guess I can understand it, but it's kind of weird. Of course, we can have you. I don't know where you parked, and they just kind of talk about where they parked. Nice to meet you. Just right out here in front of the building. Everyone's in the courtroom. I'm going to get my staff member. We'll rendezvous at some point. Okay, that's fine between the state and I and Sarah and you. Okay. Whew. So that's the end of the transcript. Really wild. Thank you, Azam, for the super sticker. Really wild, man, that this stuff happens. It's a really wild world on how this was handled and why cameras and publicity is a bad word. The public interest in these cases is so important. Cleverlit nickname. There are a lot of people stepping away from the case or no longer breathing. Thank you for keeping eyes on the case. We need everyone watching. Yeah, I mean, if you guys are interested and you have questions about specific things, I am not following every detail, reading every document in this case, like potentially Koberger or Sarah Boone or some of the other cases we've been following since their inception. Not Boone so much, but Koberger. But when something really interesting like this happens and you guys have questions, I'm happy to dig into it. And Bothwell. This sounds like blackmail. What makes it legal to use her power this way? It's not blackmail. She's giving them a professional out. So if this was all done appropriately with due process after a hearing, and she said, listen, why don't you guys just go so I don't have to, publicly do this. If you just withdraw, it'll be fine. This happens all the time in the business world that, you let people resign or a mutual resignation versus a firing. I don't find that part horribly inappropriate. I find it inappropriate that she is threatening them with public shaming in front of the media without due process of even telling them really what all of the claims are against them and giving them a chance to defend themselves. Nirvana, we never hear or see the families. Yes, zero pity on RA. Loan. Nick brought in witnesses. Don't they have to be disclosed to the defense? And how did they know to bring them? Very sketchy, in my opinion. Yeah, it's really horrible to do anything like this without, and we say this about, criminal defendants accused of some of the most horrible things in the world. Well, defense lawyers accused of things should also have the opportunity to be heard and to refute those claims. Cassie, what are your thoughts on Rosie and Baldwin offering their services pro bono as they have? I think they can do that. They're lawyers. We're all lawyers. Our time is our money. Our brains and mouths are our money. And if we want to offer that for free to a client, that is our right. And I think it's really interesting. So she's basically making a finding, not only that they can't be court appointed counsel, but they're not allowed to be on the case. And I'm wondering if this stuff all gets appealed up. Zena, the reason we should care about RA is because we have to make sure we convict the right person or persons. That's the only way to get the victim's justice. 100% agree. I second that. Wendy, a conviction could get overturned because of this. Exactly. Nobody wants that. Nobody wants that. You know what we do want? A free membership from Netwoman. I mean, listen, if you were in this live and you didn't get a membership, what are you doing? Do you not have it turned on? Nirvana, I really want Indiana to be progressive, not backward. Hopefully all of this time behind closed doors is because it's necessary. And that's possible too. Just because something happens in chambers or is confidential doesn't mean there's something sketchy going on. John, I still think these pre-docu-series are an issue. Can judges not change that or put a hold on them? Yeah, it's First Amendment issues. I agree. I hate them too. I think they can discourage them, but not necessarily like really make sure it doesn't happen. I wish these companies would make better decisions. Wendy W. And then Judge Gohl had the nerve to go out and say there's been an unexpected turn of events. I didn't even think about that. An unexpected turn of events that I knew about and planned and kind of forced to happen over the last few weeks, I guess. I don't know. That is true. I didn't even think about that. Kimmers 4K, welcome to the membership crew. Emma said, new documents have come out debunking the judge. I'm not sure exactly what this means. I'm not 100% sure what this means. But send them to me on Twitter, at Lawyer You Know, on Instagram, at Tragos Law. 10 more memberships from Netwoman. I meant to think, I didn't know if we'd have content on this holiday week. You all came through in the clutch, as always, and sent me what you had questions about, and enough of you were asking about it. We've got over 3,000 people in here. Let's get this to 3,000 likes on this video before we end. We went over an hour. We did overtime to read through this entire transcript. So I appreciate you guys so much coming on here, hanging out with me, asking questions, bringing the content that you find interesting, and we can learn together. Wiley, wild to say the least, scary to be honest, not how it should be done. I hope we agree in this chat at the very least. So I think that we can all be more comfortable with an open and fair process that's subjected to the same rules as everybody else, right? We don't want different rules just because the crime is so heinous or we think the person is so bad or we maybe feel like we're sure of their guilt before the trial. We just don't want it to happen that way. Rachel Wiley, welcome, welcome. All right. So on the way out here, Netwoman is going to give you one last chance to grab a membership because she's just gifted 10 more. And Netwoman, again, star of the show here today. Thank you so much for coming on and bringing so many people in to the membership crew with you before the holidays. It's a Thanksgiving present. I appreciate you guys so much. I really appreciate everybody that came on here, that joined, that asked questions, that hit that like button, that subscribed. You really make this stuff interesting. You make the ability for more people to learn, because if you have a question, chances are a lot of other people have similar questions. Todd, thank you, saying he's referred a few people over, maybe to the channel, maybe to the firm. If you want to hear more about, if you're new here, let me know. And in the outro, you can hear more about me and my firm, things like that. Nikki, thank you for covering this, Peter. It's like the fourth time I've heard it now, but I really wanted to hear your opinion. Yeah, hey, I know what it's like, because like I remember with certain sports podcasts, like a trade deadline happens and all these trades happen. I listen to all the podcasters I like to listen to hear their take on the trade. So I get it. I appreciate you guys so much. But that's all we got for this one. So until next time, True Crime Minnesota. I'm not out of here yet. So I've had this new obsession that I think some of you, at least some of you, are going to share. And that is Jordans. I never had a pair of Air Jordans, Michael Jordan's shoes, ever in my life. And then like 2 years ago, I bought my first pair. Now I have 4 pairs. I have a golf pair. I have a pair that I bought specifically like for pickleball because they're good like cross training shoes. And then I just have 2 pairs that I like. But I just got, so Whitney's like obsessed with them. She's got a ton. She's a shoe person. And she's the one that pushed me to get my first one. And she got me a pair for my birthday that didn't really fit right. I've got horrible feet. And So I took them back. But then when I was there, I saw this pair and I thought you guys might appreciate it because so these are the newest pair of Jordans. And by the way, and see how they're Christmas colors? Isn't that awesome? I mean, those are pretty sick shoes, right? I mean, tell me, rate them 1 to 10. But I actually wear my Jordans. I'm not trying to collect them. I'm not trying to like resell them ever. I just love them. And so I wear them. And these are the most comfortable pair that I've ever had. Yeah, I see a bunch of people saying I have a whole bunch. I love Jordans. That's so funny. Yeah, that's so funny. One day maybe we will do a Jordan giveaway, Air Jordan giveaway on the channel. That could be cool. But yeah, Christmas Jordans. How cool is that? So sorry, I don't know why that popped into my head. But I wanted to share that with you. So I'm glad we were able to do that. I appreciate you guys so much. I see a lot of 10s, a couple 7s. I see a couple 7s, but I see the 10s. I appreciate everybody that comes on here and hangs out with us as always. But now I really am out of here. Until the next one. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.